I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my triple threat co-host, Brett.
Hello, Alice. Merry Christmas. It's good to be with you at the beginning of this Christmas season.
You know what? Yesterday, when we're recording this, yesterday was Halloween, and before we even went trick-or-treating, our neighborhood had put up Christmas garlands. I was like, y'all couldn't wait one day.
Yeah, well, there you go.
So it is actually Christmas season, which I'm not angry about at all.
I mean, look, Thanksgiving's great. It's good to give thanks. I like eating, but it's kind of a blah holiday, right? Like,
it is not. I love being thankful, but I love that it kind of extends the Christmas season. I actually asked my friend today, I was like, when is too early to pull out my Christmas decorations? And she was like, not. Yesterday. So first thing coming down is definitely my Christmas train, because that can entertain kids endlessly. But can we get back to the amazing, punnerific descriptor I just had? Because you're not actually a triple threat. I'm really sorry. Actually, you're a triple threat, not in the sense of, Broadway. You can't sing or dance that I know of. You do have so many talents, but this isn't about you. The triple threat is what I'm going to call the trifecta of 2023 true crime, and that is Idaho, Murdaugh, and Delphi. These three cases, I think, will have updates every single time we turn around, and today is no different.
Yeah, I'm really sick of talking about Delphi right now. I'm hoping that things are going to calm down on that one, but they haven't calmed down yet. But you're right. There have been sort of developments in each case. More so, I don't know. I'm not even sure if the stuff we've been talking about for the last couple of weeks in Delphi constitutes major developments as much as it just constitutes major drama. It's certainly been major drama. It's taken up a lot of bandwidth, but that may be all it is.
I would say major drama, but also leading to major anxiety, thinking it's a major development. And in fact, it's not, but it is a lot of kerfuffle that we don't normally see. That's why it's worth covering, because I think otherwise there can be a lot of misleading news.
Right. Definitely. 100%. That's true. And so it is good to cover it. But there's actually sort of some substantive stuff in Idaho and in Murdaugh. We'll just start briefly with Idaho, because I think in both, actually, they're pretty minor, but they are developments. So in Idaho, as you know, there was a recent discussion. The defense there filed what I thought was going to be the craziest filing of 2023 in the law, trying to say that a grand jury has to find beyond a reasonable doubt before they indict someone, which is clearly not true. And even in their filing, they said would go against the last 200 years of jurisprudence. And shocker of shockers, the judge did not dismiss the indictment. So there's that. They did get a little bit more of a success on their motion about genetic genealogy. The judge was at least open to entertaining that they might get some information from the genetic genealogy evidence. But the judge also granted the prosecution's motion that the evidence be reviewed in camera. So the judge is now reviewing that evidence. And after that review, the judge is going to make an actual determination about whether or not they should get any of this evidence or not. So I think the judge recognized that this is so new, and even said so in the order, talked about how there's not a whole lot of case law on this. This is very new. So I'm going to take a look at this. I think whatever the defense gets will be very minor. As we've talked about in a couple episodes, they really don't have any entitlement to it. So I think they'll get some minor stuff that won't be that serious. And that'll be just another sort of kerfluffle in a case that moves on and we don't even think about it again. And then eventually, if Brian Koberger is convicted, they'll probably appeal it. Maybe we'll get some good law out of the Idaho Supreme Court on how we deal with this stuff, but not something that's going to have long range implications.
I think that's right. And with a lot of judges, especially if it's something relatively new in technology, they want to at least be open-minded about, without committing, there hasn't been any really ruling on it, but being open-minded to the kind of information that can come in. So this is not unexpected. And unless there's a court ruling that does kind of grant some big opening avenue for testimony, I don't think this is a big deal. But we have a lot of other cases to cover. So let's next hit Murdaugh, because we know Delphi is going to take a little bit of time. So you guys may remember the pretty bombastic filing by the defense for the motion to stay the case at the appellate level in order to go back to the district court because of some serious allegations of jury tampering by the clerk of the court, Becky Hill. And the last time we talked, the Court of Appeals granted that stay. As we expected, it's a procedural thing because of the way jurisdiction works. Only one court can have jurisdiction over a case at a time. So when a case is on appeal, the district court can't make any actions in the case. But if you're going to have an evidentiary hearing about any matter in the case, such as jury tampering, it has to be done at the district court level. So because there was a pending appeal, the appellate court simply said, we're going to stay this appeal so that you can go back to the district court so the district court can even hear a motion for a new trial based on jury tampering. And as we also expected, the defense filed a motion to recuse the judge. There's been a lot of talk about this because does the judge, is he going to be a witness in the case? Can he sit over this because he knows Becky Hill? He, sat through the entire trial. And we expected that they would file a motion to recuse the judge. Obviously, the prosecution is going to get to respond to it. And at this point, there's not going to be anything more to say about it, except that I still think it's unlikely this judge is going to need to recuse himself, but they've made that first step, which is asking the court to recuse the judge. Interestingly, the judge they're asking to recuse gets the motion that they have filed. So he is the one to first consider it. Now, look, he's not going to be the last judge to consider it either. So those of you thinking, well, that's just, there's no point in filing such a motion because the judge who's being asked to recuse reviews the motion. Remember, they have a right of appeal there as well.
And I don't think he'll recuse, and I think there's a couple reasons for that. I think the arguments for recusal, I think, are kind of weak. When it first came up, I didn't know how this worked and I didn't realize she was an elected official. I thought she worked for him because a lot of judges in our jurisdictions, the courtroom deputies, they're often called, or the clerk of the court, is an employee of the court, an employee of the judge, works closely with the judge, and just sort of in a different relationship than I now imagine it because she's an elected official. I just felt there's a little bit more distance there. I don't actually think he's involved in so much of the factual stuff. The defense put some stuff in their motion about that, but I think it's pretty weak. I haven't read their latest motion to recuse because it literally came out just this afternoon, but I doubt they added a lot more than what they put in when they went to stay the appeal. And look, the only reason to recuse is because it does take away an appeal issue and it takes away any appearance of impropriety because then you get a fresh set of eyes on it. The reason not to, this judge is steeped in this case. He knows it intimately. He knows what all went on in the courtroom. He saw it with his own eyes. And that's something that we value in the system. Oftentimes, initial appeals go back to the trial judge. So habeas corpus motions, for instance, start with the trial judge. They saw the hearing. They saw the trial. They saw maybe they saw the attorney in action who's being accused of being ineffective. They have that base of knowledge, and that's really helpful. And it's hard to get caught up on that. And you can only imagine it would be difficult for some new judge to get caught up on it. So there are definite reasons not to recuse. And I think recusal, it's a touchy-feely subject. You read cases on it, and sometimes it feels like you should recuse for anything. Like, well, there's an appearance. Someone could think so you should recuse. And then other times they're like, oh, no, we presume judges are impartial. We presume judges are unbiased. We presume judges can put things aside. If a judge doesn't want to recuse, unless it's a clear abuse of discretion, we're not going to overturn anything like that. So I think at the end of the day, he won't recuse, but it'll be interesting to see what he does.
Absolutely. And whenever that happens, there's going to be a decision one way or the other. We'll definitely cover it in more depth. But we always said these legal briefs were going to be brief. But they are never brief. So we might as well delve in because I don't think this is going to be a brief discussion. But Delphi, like we said, there have not been major developments in this case. Well, this latest one, there was a hearing yesterday. The latest one in that there's new counsel. Just in general in the life of a case, yeah, it could be a major development in a case. This is not, I've had many criminal defendants who have been appointed new counsel for a variety of reasons. I'm interested to hear what your experience is, Brett. The most number of defense attorneys I've had one criminal defendant have in the life of one case, like from the time they were right before indictment until resolution of the case, was 9. 9 attorneys, and it was a mix of some had to be removed because of utter gross incompetence. Some were just straight up fired by the defendant. They were all court appointed. None of them were retained because the defendant did not have the means to retain their own counsel. But 9 is probably the most I've ever seen. But again, something that is within the court's power to maintain decorum and to ensure that there's representation, adequate representation for the defense.
I have to step in and just say that I've never styled my hair. I don't own a comb. So that's for the comments. I think 5 is the most I've had. 9's crazy. That's insane. I can't even imagine getting to that. The thing is, when you deal with people who are indigent, when they have to have representation, you're usually at least going to have 2 because they typically have an attorney right at the beginning. So they get arrested, a federal defender, public defender, whatever, court-appointed counsel shows up to represent them for their initial appearance. And then they rotate off, right? So they typically start with 1, but then they get another one. And because they're court appointed, they don't get to pick. So it's not like they're going out and finding somebody. It's not like they've, built a lot of rapport with this person and really want them. So a lot of times they initially they're just not like each other at all. And it really depends. There are certain attorneys where we work who are known as being just absolute straight shooters. So they walk in and they're like, I've looked at this. You got to plead guilty. But I didn't do it. You did it. You got to plead guilty or else you're going to get railroaded. And a lot of defendants don't like that because they're hearing you're not going to fight for me or whatever, when in fact, the attorney is giving them the best advice they're ever going to get. And I have one attorney I'm thinking of who does this, who it seems like we often have fights about whether or not he has to withdraw because his client doesn't like him. Because of that, he's the one. I told this story, I think, on the last one where you weren't on, where the guy took a swing at him right before the hearing. And he was like, yeah, he took a swing at me, but that's fine. I'm good. I can represent him. It's just like, I don't know. That seems a little aggressive, but it does happen a lot. And it's not like it is in the movies. And it's just very different when you're dealing with retained versus appointed counsel because you don't know these people. I mean, a lot of times you don't know them when you retain them, but you're paying them, right? So you feel like you got some investment. So I feel like counsel changes don't happen as much when you've actually paid for the person. And
one really quick thing. I know you guys already covered this on Monday about this alleged supposed letter from Richard Allen saying he wanted the former attorneys to stay on. I agree, especially with the previous filings of his inability to be mentally all there. It was a very well-written, legally based letter. Whoever wrote the letter, whatever that is, it is not uncommon for a defendant to say, no, I still want this attorney, even if they've done something to violate court orders and the judge wants to remove counsel, and the judge will basically overrule that defendant's, pleads to keep that attorney. And here's why. That defendant, of course, is going to, unless they really hate their counsel, they're only hearing one side. They're only hearing that particular counsel telling them why they're the best counsel for them. It could be a very shaded truth. Who knows? But the judge is able to see kind of the whole landscape of things, which is why the judge has the discretion to ultimately decide if those counsel can stay on if they are appointed. And so that is not uncommon as well. I have had that situation where the counsel was just grossly inept. Missed filings, was just a terrible representative for their client in terms of legally, didn't know the law, missed filings, which are incredibly prejudicial to their client. But the client liked the guy. He's a nice guy. I don't know another attorney. This is the first attorney I've ever met. He seems to like me. Sure, judge, I want him to stay on. The judge knows better and is like, no, you are absolutely not going to get a good defense if this attorney stays on, and removed that particular attorney.
And that's one of the judge's responsibilities. I mean, one of the judge's responsibilities is to look out for the defendant and their rights because they often are not in a position to know them for themselves. But as we've talked about these issues, we talk about our experience in the law, but we haven't really gone through the law with you. So we decided, let's go through the law. Let's talk about this so people know exactly how this all works in the system. So that's the main thing we're going to do today. We're going to talk about some Supreme Court cases. We're going to talk about the Sixth Amendment, what your right to counsel is, how exactly it works, and, a little bit of how it applies in this case. But this is much more sort of broad-based. This will give you guys some understanding of this, both for this case and for anything in the future. If you're really into this, I will post at least the names of these, if not the links to them, if the links are available. There are a couple really good law review articles on this subject. One of them is called Strengthening the Criminal Defendant's Right to Counsel by Ann Poulin. That was published in the Cardozo Law Review in 2006. And the other one is Disqualifying Defense Counsel, The Curse of the Sixth Amendment by Keith Swisher, which is something he prepared for a symposium. And what's interesting about both these articles is they both come at this question from the Sixth Amendment right is far too weak and we need to strengthen it. In doing that, they lay out what the law is and they lay out what they see as some of the shortcomings. And I think some of this you kind of hear echoed in the commentary on this case. I think a lot of people feel like the Sixth Amendment right, particularly for indigent defendants, is pretty weak. And as we read these cases to you, you're going to see that. And we talked about this a little bit last time, but we're going to get into the fact that if you pay for an attorney, your rights to an attorney far greater than if you don't.
Absolutely. And we've covered this a little bit in past legal briefs about the right to counsel doesn't mean the right to counsel that you necessarily want or the best counsel or, has to be competent, but competent is open to interpretation by the courts as well. Because remember, these protections are baselines. They're not ceilings. And so let's kind of dive into some basics of the Sixth Amendment. Here's a really interesting note about law review articles for those of you who may not regularly read law review articles or may not be in the legal profession. Law review articles are academic in nature, right? There's a hypothesis posed and there's usually some problem that's identified and it's an academic way of thinking about it that may or may not be rooted in the law. So read, I think it's really great to read these articles, but there's always this like tug of war of how much you should cite or put weight into legal arguments in law review articles, which are separate from jurisprudence, which comes from the courts who have either persuasive or binding authority. So they are not weighed the same when it comes to which one the courts should follow in order to make their conclusions in a case. So that's just kind of law 101 right there. All right, let's start with the Sixth Amendment. Coming from the Constitution, the Sixth Amendment text says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Notice the Sixth Amendment does not actually say that you have the right to an attorney. I just listed to you the entire text of the Sixth Amendment. It says a lot of things that we are familiar with: speedy trial, jury, being in your jurisdiction, getting to confront your witnesses. Confronting your witnesses is another way to say cross-examining your witnesses, right? You can't just play a video of a witness statement. They have to actually appear, so you get to confront them. All of these things we know, but what did you hear missing? The right to an attorney. That came, and we covered this before, because the Supreme Court has guaranteed a right to an attorney, and that the right, honestly, is more circumspect than most people realize. In particular, because it doesn't actually appear in the text of the Constitution.
Yeah, so until before Gideon. Before Gideon, based on the text, you can go out and hire a lawyer if you want to. Like, you have the right to do that. You have the right to seek the assistance of somebody who you want to pay, but you don't have the right to be provided one. There's nothing in the Constitution that says that. And then the Supreme Court, as we talked about, and you guys can go back and listen to this in one of our earlier episodes. I think it was really one of the earliest episodes we did on Legal Briefs. Supreme Court said, look, saying you have the right to go hire somebody is great, but the vast majority of people who are in this situation don't have the means to do that. So how do you protect that right if you don't guarantee that someone actually will have a lawyer? And not just the assistance of counsel, but who'll actually have a lawyer who is going to work for them, is going to try their case for them and do all these other things. And so the Supreme Court really, in a lot of ways, kind of breathed life into the Sixth Amendment right by saying, you're going to have a lawyer. Everybody's going to have one. You're going to have one from the beginning until the end, and that's the way it's going to be. So we talk about the Sixth Amendment a lot. Sixth Amendment's obviously important, but really Gideon is where you really started to have this really robust right to counsel.
And though you have this robust right to counsel, as we've already mentioned, you don't necessarily have the right to pick exactly who represents you. And the Supreme Court has talked more about that in a subsequent case, Wheat versus United States from 1988, when they explained it this way. Thus, while the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, the essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will be inexorably be represented by the lawyer whom he prefers. So what's important there for the reasoning is not saying, haha, you don't get to pick whoever you prefer to represent you. Rather, it's saying, what is the goal of the right to counsel? The right to counsel isn't just to give you your best friend to represent you. The goal of counsel is to ensure a just judicial system for the criminal defendant, to ensure that they have an effective advocate. And there are many people who could probably provide that effective advocate, but it's also the baseline of when an attorney can be removed, right? Like just because you're preferred by your client, you may not be effective. And because the root reason for needing the right to counsel is because of effective representation, that's where kind of the spring of all of this reasoning comes through.
Now, and that is the most important thing, is effectiveness. And we've talked about this before when we talked about ineffective assistance of counsel. I mean, that's really what the Supreme Court's looking at. And that is where most of this stuff comes up, is whether or not your counsel is effective. And most times, if your counsel is effective, that sort of ends the story.
And so federal courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and the legal proceedings appear fair to all who observe them. And that was, again, from Wheat versus United States. And again, we've talked about this, that this is an independent act of the court to ensure all of this. This is why the court has discretion to ensure at baseline, this is fair for everyone, not just fair for, one side or the other, but for those watching. Guess who's watching? All of us in the chat, all of you guys watching us on YouTube, all of us listening to this podcast, we are all observers of the public judicial system, as is our right and as is contemplated by the founding fathers. And so the fairness of the judicial system is incredibly important because it is this public right.
And a lot of people, especially in the defense bar, really hate Wheat, because Wheat is the case. And if you read those two law review articles, you'll see this. Wheat is really the case that said, look, you have a right to counsel, you have a right to effective counsel. You don't have a right necessarily to pick your counsel. You don't have a right to keep your counsel that you picked, particularly if you're an indigent defendant, if you're someone who can't afford counsel. And as the Supreme Court continued to develop this line of cases, they reasserted this. There's a case called Gonzalez-Lopez, and if you followed this case, you may have even seen Gonzalez-Lopez, because people have cited Gonzalez-Lopez as an argument for why Richard Allen shouldn't have been able to keep his counsel. Because Gonzalez-Lopez is a case where counsel was removed and the Supreme Court eventually reversed the conviction and said that was a violation of this person's rights. Kind of wild how this case went down. So Gonzalez-Lopez, he gets arrested. He hires a guy. He ends up hiring two counsel. So he has one counsel who's like local, and then he has a buddy who's also a lawyer, and that guy comes in and works for him. And during a preliminary hearing, they're cross-examining a witness. And there's a local rule that says only one lawyer, one witness. So if you're cross-examining a witness, you have to do it by yourself. The other lawyer can't jump up and interject. We actually have that rule in our jurisdiction. We had a trial. I was in the middle of cross-examining a witness, had to go to a funeral the next day. The witness was going to hang over, and we had to seek permission of the court, which the defense graciously did not oppose, to have another attorney step in for me to do the cross-examination the next day, because that's what you have to do when you have one witness. So in this, they had the same local rule, but they were much more strict about it than we were, to the extent that this other lawyer was sitting at the table passing notes to the guy who was asking the questions. And the judge ruled that was a violation of the local rule and removed the guy from the case because of it. And so then and I think this is where actually Allen's attorneys got this. The guy, he moved to be a pro bono attorney. And the court obviously said no, because they've removed you. They're not going to allow you to be a pro bono attorney. And to the extent that a marshal was assigned to ensure that this person did not communicate with the actual lawyer. And the other lawyer, who didn't really like this guy, actually moved for sanctions against him, too. So it was a very, very sort of crazy, wild case, kind of like this case.
Can I interject something really quick that's been on my mind for this whole pro bono argument, that the counsel can just be pro bono and come in? So courts have ultimate discretion as to which attorneys can appear before them. Period. So Brett and I, we're barred in certain states and certain jurisdictions. And once you're admitted to that particular bar or that court, you can then appear in cases. If you file an appearance, the court can always strike you. But generally, we do practice in courts all over the country. And when you do that, you're not necessarily admitted to that particular jurisdiction. And you have to file something called a pro hoc vice, which is to say that you're not admitted to that jurisdiction. But judge, you usually have someone who is admitted in that jurisdiction say, I vouch for this person. You should allow them in. Guess what? You can't do anything in that case. And this is for every case across the country. I file these like left and right on a daily basis. I cannot file or appear in anything in those cases until the court takes the action of granting my pro hoc vice. That's in civil cases. That's in criminal cases. It's all across the board. So this is something so commonplace and it's very serious. I've not had a pro hoc vice denied. I have seen pro hoc vice denied by other applicants because they didn't follow the local rules, for example. And it's not just a rubber stamp. These courts do have discretion. They want to know that you've read the court rules. For example, I filed a pro hoc vice for a court in Puerto Rico, and they said as part of the rules for pro hoc vice, you had to read all of the Puerto Rico civil procedure rules, but they were only available in Spanish, and you had to sign that you had read them. It didn't say you had to understand them. And I even asked the court, I was like, is there an English translation? And they were like, no. So I was like, see. And so I read every word of it. I speak elementary Spanish, certainly do not understand all of it. And I asked the court, I was like, reading it does not mean necessarily comprehending it. Is that correct? And they said, C. And so I signed the form, but I saw the other attorney not sign the form because they said, I don't have the English version, and they didn't read it, and the court denied their pro hoc vice. And guess what? That attorney couldn't file anything in that case until they complied with the rules and the court granted them pro hoc vice. The point of this right here, the story right here, is that every court in every single case exercises this right to allow which attorneys to appear before them. And it's not special about Judge Gall and the Delphi case whatsoever.
Local
and any
rules
of you
are crazy.
Practicing local rules, they really are. I mean, they're as I've seen briefs struck for having the wrong font size, right? Like every court is going to be different. Some are like the footnote has to be size font 12. And if you're off, it's 11 or 9, like the default in Word, struck. This happens all the time.
What's annoying is when there's two judges in the same courthouse who have different rules, and you got to learn the judges.
Absolutely. You have local rules and then you have judges' rules, right? Like courtroom rules. I say this to explain just how commonplace it is for the court to have this type of power in order to control their courtroom with respect to who appears before them. So there's just nothing, as much as the folks who are reporting about the Delphi case want to make this seem like this is so out of the ordinary. The judge is so biased. This is crazy. I hate to tell you, but just about every single courtroom is like this across the nation.
But in Gonzalez-Lopez, there was a key distinction, and that was that Gonzalez-Lopez had hired his attorney. So he was retained counsel, and that made a big difference. So as the Supreme Court said, we have previously held that an element of this right, the right to counsel, is the right of a defendant who does not require appointed counsel to choose who will represent them. So if you're spending your own money, the Supreme Court has basically said, and every court applies this the same way, the Supreme Court has basically said, in those instances, there's a much higher bar for removing counsel. So in Gonzalez-Lopez, they said, look, we get it. You got local rules, but the local rules don't trump this right. And frankly, you kind of went overboard on this a little bit anyway. But I mean, basically, they're saying it doesn't trump this right. So in that circumstance, we are going to say you violated this person's Sixth Amendment rights. And because it was retained counsel, it doesn't even matter that the attorney he got was fine. We are not going to allow a harmless error analysis. And it is difficult to explain to you, and you're going to see this as we continue to go through these cases, how stark the distinction is between retained counsel and appointed counsel. There is a gulf between the two of them. If it's retained counsel, you got to have a really strong reason to remove them. You really need to make sure your record is absolutely clear. And if you get it wrong, the entire case will be overturned because you can't even rely on harmless error when it's retained counsel.
And this isn't just our interpretation of the law. It's pretty much straight from the Supreme Court's mouth. This is from Caplin and Drysdale Chartered versus United States, a 1989 Supreme Court case, where they said that you can't choose your appointed counsel. From the text, it says, petitioner does not, nor could it defensibly do so, assert that impecunious defendants have a Sixth Amendment right to choose their counsel. The amendment guarantees defendants in criminal cases the right to adequate representation, but those who do not have the means to hire their own lawyers have no cognizable complaint so long as they are adequately represented by attorneys appointed by the courts.
And I realize that's shocking to people. I feel like this is one of those areas of the law that if you're not a lawyer and you haven't looked into this is not what you would expect. You would not expect that kind of statement to come from the Supreme Court. I mean, this line, petitioner does not, nor could it defensively do so, assert that an impecunious defendant, so a defendant who doesn't have any money, has a Sixth Amendment right to choose their counsel. Could not defensively do so. Not just, we've said before they can't, or, they don't raise this issue. It's, if they raised it, we would laugh you out of court, because that's obviously not true. I mean, that's what the Supreme Court is saying in this, and this is a Supreme Court case. And, I realize, like I said, this is surprising to people, but that is the law, and it's the way the law has been for a very long time. It may not always be that way. Might change eventually. Those two law review articles we mentioned are certainly arguing that it should, but that is the state of the law now.
And also, the courts have said that now this is going to maybe get some people's, hair up on their necks because they're not going to agree with this, but this is just the state of the law, and that's there's no right to a meaningful attorney-client relationship. But once you understand the reasoning, it kind of makes sense. So in Morris versus Slappy, which is a Supreme Court case from 1983, they said the Court of Appeals' conclusion that the Sixth Amendment right to counsel would be without substance if it did not include the right to a meaningful attorney-client relationship is without basis in the law. So note that. The Sixth Circuit at first was like, yes, you absolutely get a right to a meaningful attorney-client relationship because why wouldn't you? And the Supreme Court specifically calls out the Sixth Circuit decision on that and say, no, there's no such thing. But they go on to explain it's not just because we're cold-hearted non-justices sitting on the bench, in this marble hall. It's because no authority was cited for this novel ingredient of the Sixth Amendment guarantee of counsel. And of course, none could be. No court could possibly guarantee that a defendant will develop the kind of rapport with his attorney, privately retained or provided by the public, that the Court of Appeals thought part of the Sixth Amendment guarantee of counsel. Accordingly, we reject the claim that the Sixth Amendment guarantees a meaningful relationship between an accused and his counsel. So note that, remember, the Sixth Amendment, which you heard the text of earlier, never said anything about having a relationship with your counsel. And again, it's a baseline. It is not a ceiling of rights. And that's because that is something kind of intangible. How would a court, especially an appellate court that's removed from seeing the defendant and seeing the interactions of the client-attorney relationship, know even how to judge whether there is a relationship and what's strong enough? Because every relationship, as you know, is on a spectrum. So is there going to be a passing grade? Who decides that passing grade? And each person who views that relationship may have a slightly different interpretation of it. And so it's really kind of unquantifiable, and it would be inadministrable to have a standard where you have a right to a relationship with your attorney.
And that leads into this question of whether or not you have a right to continuity of counsel. Now, look, Gonzalez-Lopez stands for the proposition that you do if it's a paid lawyer. So if you look at this, if you're looking for the law on this, and you look into continuity of counsel, you'll see cases that talk about how continuity of counsel is important and it's a key part of the Sixth Amendment and it's protected. That is talking about retained counsel. And there are lots and lots and lots of cases that talk about this, but I thought it would be interesting to just read from this law review article because I think this person does a really good job of laying this out. Remember, They want there to be this, and they are arguing that it should be. And they're citing all these cases that say you don't have it. And they're saying why that's a bad idea. And they're really, I mean, this is a powerful argument. I think it's an argument, if you're listening, you're probably feeling the tug of that. You know, it seems kind of strange that just because you don't have any money, you don't have any right to continuity of counsel. Now, there are reasons for that. And one of them is, as Alice and I talked about, when you're not hiring your lawyer, it actually moves around a lot more than you would think. You end up probably being represented by multiple people. And I think there's some concern in the Supreme Court that if we said you have this right to continuity of counsel when it's an appointed attorney, that's going to lead to all sorts of problems, and it's going to make the administration of this right a lot harder. I think that's one of the reasons that they say that. But nevertheless, I understand the sort of pull of this. But let me read to you from this Law Review article so you have sort of an understanding of the state of the law here. And it's a little long, so bear with me. Given that the defendant's role and involvement at trial depends heavily on counsel, the courts should recognize that indigent defendants have a constitutionally protected right to have the initially appointed attorney continue to represent them, and that this right can be overcome only under limited circumstances. Too often, indigent defendants are subjected to changes in counsel as their cases proceed through the justice system. The court's practice of permitting substitution of new counsel when not requested by the defendants undermines the right to assistance of counsel. Recognizing a right to continuity of representation would accordingly strengthen the right to counsel. It goes on to say, the defendant with financial resources is not merely entitled to receive effective assistance from counsel, but has an interest in counsel of choice that the court must consider and accord weight. As a result, a court may not deny the moneyed defendant's request to proceed with retained counsel of choice absent adequate justification. In contrast, indigent defendants have no comparable right. The Supreme Court has not held that indigent defendants dependent on the government for appointed counsel have the right to choice of counsel or any related interest warranting constitutional protection. Courts consistently hold that an indigent defendant does not have the right to select a particular court-appointed attorney. However, once counsel has been appointed, the Sixth Amendment should, remember, once again, this is an argument, this is how they want it to be, should protect the defendant's interest in continued representation by appointed counsel. The Supreme Court has not directly considered whether an indigent defendant has a constitutionally protected interest in continuity of representation. The thrust of the court's opinion suggests that the indigent defendant has no constitutionally protected interest other than to receive effective assistance of counsel. And we've read you some of the cases that say that. Therefore, the defendant is entitled to relief if the court appoints a new attorney and does not provide sufficient time for the attorney to prepare the case, rendering the representation ineffective. So basically, if they replace your court-appointed attorney with a new guy and then they're like, and trial's tomorrow. I mean, imagine if they'd done that in this case. Imagine that we were much closer to the trial date and the judge was like, okay, you guys are out because I don't like you. Putting you guys in, we're sticking to the trial date. That would be a problem. As you know, in this case, and yesterday, the court actually continued the case till October of next year, which will give the new attorneys plenty of time to get up to speed. Otherwise, the defendant must point to a specific failing on the part of the attorney and demonstrate that the defendant was prejudiced as a result. So that is the state of the law as we currently sit here, that an indigent defendant, unless there's some state law that grants them that, I wasn't able to find anything in Indiana giving them any kind of right to continued counsel, really does not have a right to continuity of counsel in the same way that they would if counsel had been retained.
Yeah. And, you know, those who are reporting on the Richard Allen case and saying this is the first time ever that someone has, you know, requested that their own counsel stay on the case and there's no reason for them to be removed. You know, I think in this case, there is self-admitted reason for removal. But let's just say this was a situation where there was counsel that was being requested by the defendant and they were being removed for absolutely no reason. Still not new under the sun. And here's why. This is the great thing about having a common law system is that there are, you know, millions of cases in our jurisprudence, and we get the benefit of seeing the fact patterns play out in many different cases over the years. And that's exactly what we have here in Daniels versus Lafler, which was a 2007 case out of the Sixth Circuit. So Daniels was accused of killing 3 children, and he was appointed counsel because he couldn't afford his own counsel. And then his counsel was replaced right before trial over his objection and allegedly without cause. So what had happened in that case was there was a pretrial motion hearing and Daniels's lawyer was the only one who showed up. That's good for Daniels's lawyer, bad for every other attorney to miss a court date. That's my like greatest fear in life is to miss a court deadline or a court hearing. Now, his co-defendant's attorneys didn't show up. So not his own representation, but his co-defendant's attorneys. The court was very irked, understandably, and issued an order to, quote, replace all counsel and pick counsel who can try this case on the trial date we currently have. Daniels tried to object the removal of his attorney who had shown up for that date, and the court told him he could only object through his new attorney, who obviously had no interest in doing so because then that new attorney would be out of a representation. So the case went to trial with his new attorney, and Daniels lost. And he appealed this issue, saying he had a right to continued counsel of his choice, all of the things we've been talking about. And here's what the Sixth Circuit said. They found no Sixth Amendment violation. They said, carrying out this de novo review, and in light of the clear guidance from the Supreme Court discussed above, we hold that a defendant relying on court-appointed counsel has no constitutional right to the counsel of his choice. This does not mean that an indigent defendant never could establish that the arbitrary replacement of court-appointed counsel violated his constitutional rights. The replacement of court-appointed counsel might violate a defendant's Sixth Amendment right to adequate representation or his 14th Amendment right to due process if the replacement prejudices the defendant. For example, if a court replaced a defendant's lawyers hours before trial or arbitrarily removed a skilled lawyer and replaced him with an unskilled one. But because Daniels does not even allege prejudice here, we must affirm the denial of his Sixth Amendment claim. So a lot going on there. Again, repeated here that there is no right to appointed counsel, but also leaving kind of open this avenue of a potential Sixth Amendment violation, but in extreme cases that even in Daniels's case was not present.
And I think it's interesting to look at this case. The Sixth Circuit does not cover Indiana, but this is an application of everything we've talked about up to this point. And the language the Sixth Circuit used, as Alice said, I mean, these are extremely limited. Number one, they don't even say that in these circumstances there would be a violation of the Sixth Amendment. They say there might be. They say, we're not saying they could never establish that an arbitrary replacement. I mean, understand what they're saying. They're basically saying, even if it's arbitrary, that's not enough. Like, even if the court just woke up and said, you know what, I don't like their names start with B, and I'm not really a B person. I'm more of a C person. So I'm going to find them a C lawyer. I don't like saying B names, right? Like, if the judge did that, but it wasn't before trial, wasn't right before trial, and the C lawyer was just as good, okay. No Sixth Amendment violation there. I mean, that's what they're saying in this case. And that gives you an idea of just how broad the powers are of a court to replace attorneys in appointed counsel cases like the one we have here. And I think it's interesting to note, this is a Michigan case. This came out of Michigan. So the way these things work is basically the guy's convicted. He files a habeas petition. It starts in the Michigan courts, and then he can appeal it to like the Sixth Circuit. So when it goes in the Michigan court actually says, I guess basically as a matter of state law, that they would find that there is some right to continuity of counsel. But it's a right that could be overcome by, among other things, I think this is interesting given where we are in Indiana, gross incompetence or contumacious conduct, which is conduct in which one refuses to obey or respect the law in a way that shows contempt. So in this case that we have in Indiana, we have both those. We have accusations of gross incompetence and the handling of evidence and the violation of court orders. And then everything that happened after it, I think, is a good example of contumacious conduct. But even the Michigan court, who said, look, we kind of think there is a continuity, they also denied his petition. So he lost in the Michigan court too, even where they're saying there is kind of this right. Then he goes up to Sixth Circuit. Sixth Circuit's like, basically no right to this at all. So it's a heavy weight. If you're thinking about the law and what the law is, and if you're thinking about what's going to happen in this case, just know there is a really heavy weight here. And the criminal procedure hornbook, which is like Westlaw puts out, and if you look into all these various issues, it'll give you little sort of rundowns of the law and what the law is going to be. It talks about this. This is an appellate issue, and this is what it says. Given the discretion, Wheat, which is the first case we talked about, and the case that I said a lot of attorneys, particularly defense attorneys, don't like. Given the discretion, Wheat provides to the trial judge for disqualifying, notwithstanding a waiver. So attempts by defendants in this case is a good example. In the Delphi case, you have a defendant who is attempting to waive any of the issues. He sends that letter to the judge and says, look, I realize this is an issue. I waive this. I'm not worried about it. I believe in these lawyers. I want them to remain. Doesn't matter. Notwithstanding a waiver, that course of action is seen in presenting the least room for a successful appellate attack, given a case with a realistic potential for presenting an actual conflict. So it's just not something that's easy to win on appeal if you're dealing with the removal of counsel who are appointed. And let me just say, even if you have retained counsel, that doesn't mean they can't be removed. I think this is also interesting to look at because I think it gives you an idea of why what Judge Gold did probably is going to stand up no matter what, going all the way back to Gonzalez-Lopez. So Gonzalez-Lopez is probably the most full-throated example of a Supreme Court case talking about when attorneys can't be removed. As we said, the retained counsel. If you have retained counsel, it's really hard to remove them. But the Supreme Court, in that case, makes sure to point out we are not saying they can't be removed, even if they are retained. So I want to read you what they say there. The court has, moreover, an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. None of these limitations on the right to counsel is relevant here. This is not a case about a court's power to enforce rules or adhere to practices that determine which attorney may appear before it, or to make scheduling and other decisions that effectively exclude a defendant's first choice of counsel. So Gonzalez-Lopez is reaffirming, they quote Wheat in this part of the opinion, reaffirming the idea that courts have this inherent ability to remove attorneys, both retained and appointed, to do things like ensure ethical standards are upheld, to enforce rules. They can do it in those circumstances. So this is one reason that I think, and these are two different questions, but even if you think that Judge Gull was wrong to remove Richard Allen's counsel, I think the concern that eventually that's going to lead to a successful appeal are probably less of a concern than you think it's going to be. We pulled up some stats. This is from one of those law review articles. They have disqualifications, reasons for disqualifications from between 2003 and 2012. And they actually show both prosecution and defense because prosecutors can be disqualified as well. I think there's that murder case in Georgia, some famous rapper and his prosecutor just got disqualified. I'm not entirely sure why. I'm not really following that case, but some of you will be more familiar with that. But here's some examples. So the reasons for disqualification, 50%, by far the most, and this is what you see the most, is there's some former client issue. So this can be a thing where a former client is going to testify or something along those lines. And that's a circumstance in which you're going to have to disqualify yourself. But a couple that are more relevant here, appearance of impropriety, that was 11%. Other misconduct is pretty small, 1.3%. Personal interest could be 6.7%. Misconduct with a witness, 0.7%. So misconduct, it's not super common, is the reason that attorneys are removed, but it does happen, and obviously that was the reason in this case. Though I think you could also argue there became a conflict in this case as well, because once the attorneys had claims being made against them, then all of a sudden they're hiring their own lawyer who's making their own arguments for them. Seems like they're no longer just fully invested in the interest of their client. There's a conflict from their own personal interest and the interest of their guy.
Here's the thing. We're not saying what we want the law to be. We're merely telling you guys what the state of the law is. And it's been contemplated. All these cases are back from the 80s. This is not new. And if you want it to be different, that's a different discussion to be had. But it's important to know what the state of the law is today in evaluating what's happening in Richard Allen's case.
Right. And I think that's a major distinction. And I think it's something you really have to think about. There are good arguments that the law does not adequately protect the rights of indigent defendants. And those arguments, like I said, read those two law review articles and you'll see them. They make those arguments. We read some of those arguments. But the reason they're having to make those arguments is because the state of the law right now is judges just have great power to do this kind of thing. And I think the other thing it's important to remember, because when you talk about this, the arguments get all mixed up, right? So one of the things that gets mixed up is whether the judge did the right thing versus whether she did it in the right way. And I think something everyone should be able to agree on, I think. And of course I think this because this is what I think. I think everybody should be able to agree that the admitted conduct by the defense, like there's some question like, well, they should have an evidentiary hearing and let the defense make their arguments. The defense in their filing admitted gross negligence. They admitted gross negligence. In their own words, they admitted that. They admitted that they allowed people who were not involved in the case to access this information, not only access it, but take pictures of it. And maybe they only allowed that because they were grossly negligent. I'm not saying they did it intentionally. That in of itself is such a massive violation that it gives the court the authority, particularly when you think about the broad authority the court has to act in this way, and just change the perspective. When I read those emails to you in the last time, it was pretty clear that initially the defense didn't realize they were the ones who were grossly negligent, or this is the way I read it. They thought it was the prosecution. And they thought it was maybe the police. And they were setting it up with the whole like, oh, he's known about this for 24, 30 hours and he didn't mention it. And I think they were really getting ready when it turned out the leak came from the prosecution and the police. It wouldn't have been the defense that was getting recused. They would have been saying, these people are negligent. This is incredible. There's so much bias to our client to allow crime scene photos out. This is terrible. Something needs to happen to them. Imagine that was the case. Imagine a police officer had done this. Imagine a police officer had left a photograph of 2 murdered young girls, one of whom is nude, sitting out somewhere, and someone from the public took a picture of it and shared it online. Imagine that happened. Would people have been like, oh, not that big a deal. I mean, it probably would have come out eventually. It would have been in the trial. Nobody would have said that. No one would have said that. They would have said he should be fired and everybody else should be punished. Imagine the prosecutor had done it. Imagine Nick McClelland had done that, or someone on his team had done it. Is there anyone who currently is defending Richard Allen's counsel who would have said, no biggie? Everybody makes mistakes. These things happen. That I do not imagine people would have said that.
I don't imagine that. And let me also address like an elephant in the room, which is everyone said, well, Baldwin admitted that the leak came from his office. Rosie had nothing to do with it. Remember what we said in a previous episode, that the entire team that is representing a client, whether it's the prosecution or it's on the defense, is a team, right? You have to take responsibility for everyone. We've talked about this when our agents, people who work with us on prosecuting a case, may have kept back material that we didn't even know about. We can't say, Your Honor, we had no idea that there was this, exculpatory information, so we never turned it over. That's not good enough because the agent is part of our entire team and we have to take responsibility for what they had or not had. And here's what we do. We don't turn a blind eye to those sorts of situations. We actually sit down with all of our agents and ask a slew of questions that a lot of them roll their eyes at because they're like, I know. But they're questions like, have you searched all of the places that evidence could be? Have you opened up all the drives on your computer to make sure that there's no evidence there that you forgot to pull onto the hard drive that you gave me in order to turn over to the defense, et cetera, et cetera. We do these types of like litany of questions ad nauseum with everyone who works on the case, and we do it at multiple points in the case to ensure that we take responsibility for everything that happens on our side of the V. Same with the defense. I get that it's saying it's from Baldwin's office. You know what happens when I have a protective order in one of my cases, whether I'm on the prosecution or the defense? I send out annoying emails to every single person who touches my side of the case, remind them of their obligations under the protective order, remind them how they have to treat that material, how they have to dispose of it. If I am represented on the docket for any case, it is my responsibility to make sure my co-counsel are complying with all of the orders of the court because we can all fall for it. So it is not an excuse to say, I didn't know what that guy was doing. You all represent the same client and you all sign the same order.
And look, it's not about these attorneys. Like everybody's like the attorneys have some right to be heard. The attorneys have, a right to confront witnesses. And the attorneys have a right to trial. That's not what this is about.
This is versus Richard Allen.
Exactly. And this notion that they're being treated unfairly. No, it's not about them. And I realize they have made it about them over and over and over again, but it's not about them.
And one really quick note, because I think you bring a really good question, whether the judge did the right thing, but maybe whether it was in the right way or not. One note, a lot of people keep saying it was the wrong way because she should have just reported them to the bar if it was so bad. Guys, Did you know that reporting someone to the bar is a whole lot worse than removing them from your case? Reporting them to the bar removes their, if they're found to be in violation of bar rules, ethical rules, they lose their profession. Most judges, most attorneys don't want to rise to that level to raise a bar complaint against someone. There have been bar violations left and right around me before by other attorneys. I have never reported anyone to the bar myself because it is an incredibly serious allegation to make against another attorney. Same for the judge. The judge's first step, if they think there has been a violation of the attorney's duties, is to deal with them in her own courtroom. Because it would be weird for her to think that they have done something that violates their ethical obligations and can be reported to the bar, but don't remove them in her own courtroom, because she has actually fallen down on her job to ensure that, there's justice within her own courtroom. So that's kind of a red herring argument if you're hearing people say, oh, just report them to the bar. It is a lot more serious to report someone to the bar than to take action in her own courtroom as she did in this case. So whether she did it completely in the correct way, I think there's more discussion to that. But in terms of kind of broad strokes, whether she should have removed them or reported them to the bar, this is what I think every judge would have done. And the only time I would think a judge would report someone to the bar is after they've taken the actions within their own courtroom and thought there was like criminal conduct, and they may take the additional step of either referring it to the prosecutors or reporting it to the bar to ensure that this attorney doesn't continue to do harm.
Yeah, when I was clerked for two different judges, when I clerked for one of them, there was an issue where some attorneys misrepresented some things to the court, and there was a big discussion about whether or not to report them by the judges. The judges really were debating whether or not they should be reported to the bar because they felt like it was a pretty serious thing. And I think at the end of the day, they decided not to. They kind of decided to give some grace to these people. But it is an incredibly serious thing to do. And look, like I said, I think everybody should be able to agree that doing that, even if that's all they did, even if the things they admitted to are the only things they did, I think the judge could find that that's gross negligence. And here's the other thing about that. The law is not, there's an absolute right and there's an absolute wrong. Judges are in their position to make these kind of calls. You may disagree with those kind of calls, but in order for them to be wrong legally, it has to be something that is completely out of bounds, that basically no reasonable person would think. This is such an unreasonable thing she did. No reasonable person would agree with that. That's how high the bar would have to be. So even if you disagree with her, it doesn't necessarily make her wrong in the law. If she's wrong as a matter of fact, it doesn't mean she's wrong in the law. Now look, that doesn't mean you have to agree with exactly how she did this. We have criticized how she did it. I think it was a mistake. Particularly knowing these attorneys and how bombastic they had been, it was a mistake to just let them get away with the in-chambers conference. There was nothing wrong with the in-chambers conference. It happens all the time. They should have had it. They should have discussed it. She should have told them what was going to happen. And they should have gone back out there and had the hearing. And they should have put it all on the record, and they should have had the evidence laid out there. We have been talking about this for a week without knowing that 10 days before that hearing, the prosecution was asking for them to be removed. That they had been on notice for more than a week that this was on the table, and that the reason it was on the table was because of their negligence in the handling of this evidence. We didn't know that because we didn't have the public hearing, and it wasn't until those documents were released in a mandamus filing where they just attached all these documents that weren't public, which is something. But as I said in the last one, thank goodness for transparency, right? Because we now know that. We now know something we didn't know before.
So know what we're saying. We're actually saying that we're kind of attacking the process that she went about it, not because it would have helped defense if she did it the way we thought it was proper, which is to have it all out in the open. We're saying it actually would have cut off the defense from making a lot of these ridiculous filings because they're misrepresenting what's happening by saying that they were bombarded and they had no idea what was coming. If we had known all of this in the public, I think it would have cut off their ability to make these kind of arguments that are plainly against the evidence that they're trying to get released.
It kind of reminds me of the Murdaugh case, where in the closing, the argument of the attorneys is about how SLED didn't contain the scene and let all these people in and all this stuff happen. And it's like, that's because Murdaugh called everybody in the world and had them come over. And they're right. SLED didn't do that, but it's kind of funny them using their own client's actions against the state. And it's sort of a similar thing. Because she didn't do this thing, because she sort of like did them a solid, let them do what they did. We spent a week more. We're still talking about this, and we'll be talking about this for a while. I mean, they filed one mandamus. We'll see whether or not that's successful. I think a mandamus to have them reappointed is going to be most likely will fail. One thing, I'm just curious what their next move is, because one possibility is the pro bono thing was rejected. Maybe they'll just say, well, she could remove us once we're pro bono, but she can't block us from being pro bono. So mandamus that we get to come in pro bono, like something like that. I don't know. I've been trying to figure out what their next move is. But I think for me, I've thought about this a lot, like why this bothers me so much. And I think one of the reasons is because the actions of the lawyers, the lack of respect, the lack of decorum, the lack of treating the law as the way it's supposed to be. And I've had a lot of lawyers have reached out to us and said, I've never seen anything like this. Never seen anybody act like this. And I think one of the problems, and it took me a while to put my finger on this is not how you react when a judge rules against you. Judges rule against you all the time, and they can rule against you on really serious issues. If you're a criminal defendant, basically everything that happens in your trial, your constitutional rights are on the line. You file a motion to suppress, you are saying that your Fourth Amendment rights were violated. You file a motion to dismiss the indictment, you're saying that, your Fourth, Fifth, or Sixth Amendment rights were violated. And that's really important, and it's very serious. And when the judge rules against you, they're essentially, if you truly believe that, they're essentially saying it doesn't matter. It doesn't matter that you think your constitutional rights are violated. We're moving forward. But what you don't do in that circumstance is start a whisper campaign about how the judge is corrupt, or start filing frivolous motions, or show up at the hearings and disturb things. You file appeals. You preserve issues. You move on to the next thing. Every lawyer has judges who've ruled against them where they thought what the judge did was wrong. But that's not how you react, because they're the judge. And Judge Gold, you may think she's wrong here, but if you're saying she's incompetent or corrupt, you're just wrong. She's not. She's not. She might be wrong. She might get this wrong. She might be overturned eventually. She has made mistakes in the past. She's been overturned before. All judges have. And, I have one of my favorite judges to appear in front of me. We've talked about him before. Never rules in my favor. It's like, I'll make arguments and he'll say, that's a good point. And then he comes back and he's like, I don't find counsel's argument to be persuasive. I'm like, I know you don't. And it doesn't matter how much I think I'm right. I don't get to pound the table and say, I strenuously object, Your Honor. That's not how it works. And it's important that it not work that way, because it's so important that people have faith in the judiciary and they don't think that every judge is corrupt just because they rule against the defendant or rule against the prosecution or do this thing they don't like or do that thing they don't like. And just as a society, that is making it harder and harder to get justice for victims and to get fair trials for defendants. And we have to stop acting like that every time we don't like a judge's ruling.
Amen. I couldn't say it any better, Brett, except that, I think most lawyers were brought up in the kind of environment where we don't even speak poorly of judges in the privacy of our own offices, right? It is a taboo to do so because of the respect we are supposed to hold them. Now, it is very different to gossip, speak poorly about someone, attack them ad hominem, than it is to appeal what we think they've legally gotten incorrect. But we are all very, we've gotten briefings, we've gotten trainings in multiple of our jobs, Brett, where we are told you do not talk poorly about a judge. If you are unhappy with a ruling, keep it professional. Stick with the facts. The judge got this wrong. Really, this case from the Supreme Court, dictates a different outcome than the judge said. We should file an appeal because of these reasons. Not the judge is so stupid. The judge doesn't even know what they're doing. Gosh, I can't believe I have to appear in front of that judge. And the reason is because of all the reasons you just listed right there. There is decorum that is expected of all officers of the court, which are attorneys. And what we're seeing in these filings and in these representations is something that all of us as, attorneys and members of the bar have agreed not to act like. And it reflects poorly on all of attorneys, and it attacks the system, and it hurts people who are seeking justice from the justice system.
Yeah, and I don't know how this is all going to play out in the end. I mean, I really don't. I remember when I was just starting out as a lawyer, I might have been when I was clerking, I can't remember. I said something about a judge that I didn't like. And my boss at the time was like, there's always going to be a judge X, like whatever the name was. There's always going to be a judge you think is always wrong. Your job is to do the best you can and, be a professional. And it was kind of along the lines of what Alice was saying, like an early lesson, an important lesson that this is the system that you are pledging to uphold and defend. You have to make your best arguments. There's always going to be that judge. And guess what? That judge has a boss too. And you're going to be able to make that argument. And if you're right, if Judge Gohl is corrupt and incompetent and wrong, then there will be a time where that appeal will be considered and the rights of the accused will be vindicated. And that's the way to do it. And I'll just tell you, and you may be saying, yeah, but then you're going to have a trial and all that stuff. Yes, but I'll just tell you, the stuff that we see going on now, the filings that we see going on, the weirdness on Reddit or wherever, that's not going to change Judge Gohl's mind. All that's going to do is undermine the faith and the trust in the system that you need for it to work. At the end of the day, this will be decided by a higher court, not by people yelling and screaming. And I just really hope that people can try and come together around that fact. The personal attacks on the judge have really just gotten to a level that it's not healthy. And this judge, I sometimes wonder if she'll just recuse, just say, look, this is too much. That's kind of what happened with the first judge in this case. First judge in this case, he filed something. I can't remember exactly what it was, but it kind of showed that it was really getting to him. The pressure was getting to him. And after he filed that, he just recused. And that is not going to get us to justice for Richard Allen or justice for these kids any faster. The more upheaval you have, the less likely that's going to happen. And that's what everybody wants, right? Everybody wants that. We want Richard Allen to have his day in court. We want the girls to have justice, but we got to get to the day in court for that to happen. Okay. Well, has anybody got any last questions? This has been a long one. Sorry, guys.
These were all really good questions. And by the way, we talk heated because we love the law and we love this profession and we want people to understand. And the questions you guys raised, you're not the first ones to raise them. We're seeing them all over social media. And that's why we think it's really important to address them so that you have a better understanding. You can disagree with us, absolutely. But what we're trying to do is to explain to you the state of the law so that you can be better consumers of the news, in this case and others.
And I'll just say this one last thing. We've said this before. It's kind of a myth that the law is about technicalities. There are certain technical aspects that are incredibly important. I don't even think they're technical. I mean, I guess you could call them technical, but there are certain things that if you do them wrong, the entire case can be undermined. We've talked about a few of these before. Improper Batson challenge. If you seat a jury on the basis of race or the basis of sex, that's the kind of thing that just undoes an entire trial, no matter what. Very few of those things. So there may be things that Judge Gohl should have done. Like, people have pointed to a few things that I don't think apply, but just imagine they do. Like, there are rules about if a lawyer's going to withdraw, they have to file something in writing 2 weeks before. That really is about lawyers and ensuring that lawyers don't abandon their clients. But just assume for a second that somehow applies to the judge. If we get through the end of this and Richard Allen's convicted and it goes up on appeal, nobody's going to be like, aha, you totally were justified in removing these guys because they absolutely were grossly negligent. And Richard Allen has no right to continuity of counsel, but you didn't give them the 2 weeks. And since you didn't give them the 2 weeks, we're going to do another trial. No, that's where harmless error would come in. So there may be little things here or there that I think, because the judge unfortunately did not pursue that open course of having that hearing and then removing them at the end of that hearing. If she'd have done that, I think it would have taken care of a lot of this stuff. But she didn't do it. I'm not an expert in Indiana law. Maybe some of that stuff will come up later. It is not the kind of thing that I think will result in a trial being overturned. The real question is, can you remove these attorneys for what they did? If the answer to that is yes, I think the judge is fine.
So, with that, Brett, is there anything else you'd like to add?
No, we'll try and attach these opinions to the episode, so if you want to look them up and read them, you can.
Well, thanks, guys, for these great questions. And, we love talking about this stuff. Unfortunately, I don't think this is the last time we're going to talk about the trifecta of these cases of 2023. Hey, look, 2024 is right around the corner. There could be some sleeper true crime legal brief material just waiting to rear its head. But we will be here to cover developments and any questions that you have to understand the developments in these and other cases. So please keep writing in your questions at prosecutorspod@gmail.com, on Twitter, Facebook, Instagram. We're at prosecutorspod. We love hearing from you. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. You know what? Halloween was just yesterday. People want to know, how was your Halloween? Awesome. The Christmas of the Brett household.
Oh, it was amazing. We had so much fun. The kids were astronauts, and we were wearing our NASA shirts, so we were like...
You were a family cohesive unit.
Oh, it was wonderful. Yeah, we got a lot of candy, saw a lot of really awesome other people dressed up, a lot of great decorations. We had a great time. It
was, I think there was like massive candy inflation this year because usually they'll be like, take one or take two from a bucket if somebody leaves it out. This year was like, take 5, take a handful. I was like, no, don't get more, kids.